So I think we're going to make a start here. Hi, everyone. Welcome to this first Babbel webinar. Very excited to be hosting this. So before anything else and we get kind of stuck into it, just some quick intros about myself and my fantastic colleague and co-presenter, Shay Brown, in a second here. So I'll be your master of ceremonies. My name is Benjamin Lange. I'm the Chief Operating Officer at Babbel, and I lead our ethical risk assessment function. My background is in strategy consulting. So for the past 10 years, I've particularly focused on work in organizational ethics, so including responsible innovation, use, ethical decision-making, and ethical culture change in organizations. And just like some of our other babblers, I also have a research hat and I'm rooted in academia. So I'm a research fellow in ethics at the University of Munich in Germany, the LMU. So much about me. Shay, do you want to say a few words?
Yeah, thank you, Ben. So I'm Shay Brown. I'm the founder and CEO of Babbel AI, and we'll talk about Babbel in a minute in terms of what our mission is and what we're really aiming for. But I'm also a professor of astrophysics at the University of Iowa, and I do a lot of research separate from astrophysics now on algorithmic bias, risk assessments, and I'm a fellow at For Humanity. For Humanity is an organization that puts together audit criteria for autonomous systems. And so it's been my passion to really think about the ways in which AI can propagate harm and ways that we can mitigate that. And this webinar is sort of one picture into the sort of things that we do in order to do that.
Great, thank you. So let me start by sharing my screen here. I think everyone should see now my little presentation here. Perfect. So as you know, the aim today is to talk about New York City's local law number 144 coming into effect in January next year, which will require independent bias audits for automated employment decision tools, so-called AEDTs, used to substantially assist or otherwise replace decisions in hiring or promotion. Now, today we're going to focus especially on the notion of a bias audit, and we're going to explore how we at Babbel help employers and vendors meet the requirements of this new law. So just very quickly, what's the plan? We'll first talk about the law, then we'll give you an insight into how we at Babbel approach bias audit with respect to this new law, and then we have the rest of the time for Q&A. So we'll aim to keep the presentation at 20 minutes, be conscious of your time, and leave the rest for discussion. You see Kwa here from our technical team is also involved in the technical bias audits. He'll be moderating and he'll be kind of running behind the scenes, making sure he's picking up on all of your questions. Now, you don't have to wait until the end of the presentation to ask us anything, so you can just put your questions in the chat. They'll pop up here for us, and then we'll just pick them up. So feel free to fire away as you see fit. Great. So to kick us off and bring us all on the same page about who we are at Babbel as a company, let me say a few words to that effect. So we are a boutique advisory firm focusing on responsible AI. We combine leading research expertise on the one hand with extensive practitioner experience in AI and organizational ethics on the other to drive impactful change for our clients. Now, why do we do this? This is all to further our mission up here on the screen, which you see, which is to make sure that algorithms are safe, fair, and tethered to real human concerns. This is what we care about, and this is why we do what we do. Now, what do we do in particular? So there's really 4 key services that we focus on here at Babbel. You see them here. So the first one is AI governance gap analysis. So these are targeted assessments of a client's current responsible AI practices and governance in relation to current and, of course, emerging standards, regulations, and best practices. Then we also conduct and have experience in ethical risk and impact assessments. So these are deep assessments of a particular algorithmic socio-technical system. So we don't want to just look at a singular algorithm, but we look at the broader socio-technical system and how humans interface with it to determine ethical compliance, safety, liability, and reputational risk. Now, the third bullet point here that you see are bias assessments and audits, really relevant, the most relevant for kind of our webinar today. And these are deep dive technical assessments of potential bias in an algorithmic system, where we make use of some of the inputs from the ethical risk assessments as well. And of course, fourthly, we also do corporate level training on responsible AI. And why am I saying this? The kind of basis and the gateway into our discussion today is really the bias assessment that we've conducted and what's relevant for us. Shay will go into some detail on this here in a second, but really one thing worth highlighting is that our effort over these past months has concentrated on translating our experience and conducting these deep dive bias assessments. They're very kind of extensive and rigorous endeavors. We've done quite a few of them now over the years. And our aim has been to translating those into very targeted offerings that are appropriate for this new NYC law, that are streamlined, scalable, and that minimize, of course, the burden on employers and vendors. Okay, so much from myself. Shay, handing over to you.
Yeah, thank you very much, Ben. So now we're going to focus a little bit on what this law is. And I think a lot of you probably already know quite a bit about it. If you're here, you're interested or concerned, and so you probably know quite a bit. But we're going to go over some of the basic facts for those who may be completely sort of new to this. But essentially, what happened? New York City has passed a law which is going to govern the scope. The first fact, the scope of what it's governing is these automated employment decision tools, or AEDTs. And so if there are AEDTs which are used in New York City and used on New York residents, then there are certain obligations that you have to have under the law. And what an AEDT means technically is something that we have in the appendix. We can talk about. There are specific requirements for what counts as an AEDT. Who must comply? So the law is quite clear here that employers and employment agencies are the ones that need to that have the requirements under this law. Vendors are not explicitly mentioned. However, as a lot of you probably know, in order to do these requirements that we'll talk about in a second, vendors typically do need to be involved closely with the employers. So what is actually required here? Independent bias audit. We have it in quotes here because that's what we're talking about. The results of that bias audit need to be publicly shown. So on the website of the employer, there has to be a link to this bias audit, a public summary of it. And then there are candidate notifications. And so there's a number of things. We won't talk about those, but the candidates do need to be notified 10 days ahead of time, which is a difficult task. And there has to be an opt-out for them. When is it required? This starts January 1st, 2023. So we're not very far away, which is adds a little urgency to this discussion. The penalties. So the penalties start small, but they get up to $1,500. But that's per violation, and that's per day. And if you violate any of the sort of subsections of the law, that's a separate violation. And the enforcement agency here is the New York City Department of Consumer and Worker Protection. And they've already gone through one round of comments on this, and they are the ones who will be making further rules associated with this. So let's step back for a second and talk about where the law is clear. So, and there's a lot of places where it's not, but there are a few where it is. So it's very clear that the target of evaluation is an automated employment decision tool. And which tools fall under that is also fairly clear. They do state that it's something that has to be statistical in nature, using things like machine learning. It has to significantly augment the decisions used in either hiring or promotion in the city. And there are some ambiguities there at the edges of what might count for particular tools, but for the most part, it's quite clear. And it's very clear that there has to be a bias audit, and the language is impartial evaluation by independent auditor, and it has to evaluate at least disparate impact. So it's going to be a testing for disparate impact. That's among other things. And that has to be disclosed. So there has to be a publicly available summary of those results. It's not necessarily clear exactly what goes into that summary, but it is clear that that is a requirement of the law for you to be legally operating one of these in New York City. So there is also a number of places where the law is unclear, and Babel submitted public comments outlining a lot of these, and I'll just quickly go through it because it's relevant for our discussion. The definitions. So definitions of what a bias is a little bit unclear. And so bias is different than disparate impact. And so they outline that a bias audit has to include disparate impact, but there could be more things, and bias is inherently different than disparate impact. And audit, like what does it mean to have an audit? And together with independence, there's some lack of clarity as to who actually should be doing this, and whether it's audit in a very strict sense, like let's say financial auditing, or whether it's something like a self-assessment or internal audit. And I'll talk more about this in a second. So then there's disparate impact testing itself. So typically disparate impact testing is done over an entire selection process. And if you're thinking of like the EEOC context, if you were to find evidence of disparate impact, then there may be an investigation into sort of the component parts along that process. But here, this law is asking to test an AEDT sort of in isolation. And so it's a little bit unclear. These are not exactly the same thing. So thinking about it in the same way, it's not necessarily appropriate. There are some nuances here and some ambiguities. Another thing is the availability of demographic data. This is one of those things that ties in with the next bullet point. But typically, employers are the ones who are collecting demographic data, but a lot of times the vendors are the ones who are going to be required to do some of the direct testing. And so whether they have demographic data or not really is in question. And there's a lot of reasons to not collect demographic data. And so there is some question as to whether you can use things like proxy variables for testing these. And that's something that's unclear and open for discussion. And then the responsibility of the audit itself. So employers are the ones who are required under the law to have these done or to do these. But like I said, vendors are often the ones that have the most information. They are the ones who have access to the algorithms. And so there's a little bit of tension there as to who exactly is doing the testing. And then there's a further question of, let's say a vendor does some bias testing. Is it appropriate for an employer just to reference the results from that vendor? And I think there are a lot of reasons to question whether that's a sensible option, because there are lots of different knobs that you can turn, typically in these AEDTs, that are employer specific. And so this is an area of ambiguity. So moving on to what should you be doing right now? So given these ambiguities, I think there are a number of things, and given the amount of time that we have left, I think there are a number of things that should be started now if they haven't been started already. And one is communication. And so I think vendors and employers are communicating with each other, but if they are not, then I think that communication has to start now. So vendors in particular need to be communicating with the employers in terms of what their needs are, if they're trying to do their own assessment on the employer side, or whether the employers are expecting the vendor to be doing the testing and what that actually entails. And the same thing for employers. You need to be talking to your vendors about what kind of testing have you already done. How much can you use to support the evidence that there's no disparate impact in these tools? And so the communication has to start now. If that hasn't started, then it's critical given the time constraints. And then there is risk assessment. And this is also for both employer and vendors. And we're a little bit biased in this because we've done a lot of these kinds of tests for bias in algorithmic systems. And what we have found is that there has to be, these bias assessments have to be informed by the ethical, the compliance, the regulatory risk, the liability risk. You have to understand the risks associated with these socio-technical systems in order to really get the bias testing right and to be measuring what you're supposed to be measuring. Now, disparate impact is a very clear notion, which depends on selection rate, who gets through the system. But there are going to be a lot of AEDTs which are sort of going to fall under this law, but are not necessarily something that you can clearly articulate in terms of just selection rate. They might be supportive algorithms that where it's unclear exactly how you're going to measure an adverse outcome for that AEDT. And so getting a risk assessment done, get just a group of people together in a room to figure out what does an adverse impact look like, or what does an adverse outcome look like for our AEDT, and that's both vendors and employers, is going to be critical, because you need to have a metric for this. It's something that we'll be able to talk about in future webinars as well, the specifics around that. And then document your current testing for bias for vendors. So you need to start, if you haven't done testing, of course you need to start testing, but if you've done testing already, it's important to start documenting that, because you need to be able to show that you've done something, either for your clients, which are the employers, or for regulators. And then on the employer side, you have to, if you haven't, start recording demographic information that is specific to the AEDT. So it can't just be that a lot of people apply and then certain people get hired and you're recording demographic information for those people. You have to narrow it down, and you have to get it for each AEDT, who passes through that part of the funnel, because that is what's critical for what we would call expected disparate impact of that particular tool. So how do we approach this? So, I've talked very generally here. So what Babel has done in the past is, as Ben mentioned, very deep dives into these issues. So we've gone very hands-on and tested systems directly for bias. In some cases, collected our own data that was very specific, done our own ethical risk assessments, which sort of measures what are the risks associated with these tools. But that's a hard ask to do. And so if we go on to the next slide here, we can start thinking about the ambiguities. So let's focus a little bit on the ambiguities in some of these terms. And independence is a really good one to start with, because there's a spectrum of what you can consider independent. There is all the way from, on one hand, you can have a total self-assessment. So you just do your own testing, you do your own homework, and that's what the testing is. And then on the other end, there is something that is, I think, unambiguously compliant with the law as it's currently written, which is impartial evaluation by an independent auditor. So it could mean many things, but one thing that it definitely would mean would be having a third-party independent auditor come in and test your system for disparate impact. And when I say independence, I really mean independence in the sort of the Sarbanes-Oxley type independence that financial audit has. And so that is unambiguously, in our opinion, and this is not a legal advice, but in our opinion, I think that it's hard to construe that as not being compliant with those words. So, but that's a very expensive process. We know, because we've done that. It's a very labor intensive. It's a very good process, and it's something that we find very valuable and important to do. However, it is a big ask, especially if it has to be done every year. And so if we think about what's the most proximal thing to this unambiguous notion of compliance with independence, we think that, as in financial auditing, allowing the employers and the vendors to do their own testing according to some sort of standard or criteria that have been laid out and are publicly available. And then the independent auditors, it's their job to come in and do the verification of that testing. And so the approach that Babel is taking is one where independence is really it's prime for us. That's a very important thing, and it follows what For Humanity is advocating for, and we think that independence is very important. And so we recognize that people can do their own testing, and that as long as that testing is documented and follows the criteria which have been publicly laid out that everyone can see, we can evaluate that testing. And so what does that entail? So in practice, what that means would be there would be documents submitted. So we have criteria which we can show everyone. It's publicly available. There are different tiers of the criteria, but at the most basic level, it's to be compliant with this law. And you would submit documents for review. And so those would be checked by an auditor against the criteria. And then there would be a claim verification process. So claims that were made in the document, reference, let's say, to third parties or reference to data sets that were being tested. It would be the job of the independent auditor to verify those claims. And anyone who's done financial auditing will find this very familiar. And then there's an opinion as to whether there is sufficient evidence that the criteria have been satisfied and that everything that was said in the documentation, in fact, did happen. Now, what this means also is that there are some caveats here. There are some limitations. If we are to have this independence, and this is the model that we're going to move forward with, we can't be doing advisory services with the same companies. So if we advise you or we try to help you on doing your own bias audit, let's say, we then can't go and audit you. That's something that we strictly adhere to, and we have sort of a code of professional ethics associated with this that we would not do that. Further, we can't give you prescriptive corrective actions. So if we do an audit, we can't say, this is how you fix the problems. And so to sort of get around these 2 points, we're offering a lot of free education, and we're trying to be as transparent as possible. And we're going to be releasing criteria, and if you want to see it, you can see what it entails. And we're trying to be as specific as possible so that people are prepared for what it would take to do what we think is an appropriate disparate impact test and to demonstrate that has been done. And this also means, we can't do the direct testing. So that's something that in theory we can do, and that's what we've done, and we're very good at that. But in order to make this an efficient process that is scalable, that's something that can happen every year and doesn't break the bank, we can't go in and do the direct testing. So there are requirements that you are doing the testing, you're keeping the records, and according to the criteria, and we are verifying that. And so these are just some of the constraints that we have. So moving on, what happens at the end of this process? So this is our proposal, and I've made the argument for why we think this is a reasonable, highly proximal to unambiguous compliance as possible in terms of independence, especially. What we would do after this is that there would be a certification, and so if all the criteria met, the opinion was positive, we would certify this, and we would do this in the same way that an auditor would certify financial statements or would submit an opinion. And we would produce a public summary of the results, which the employer or the vendor can refer to. And it will be agreed upon ahead of time. There'll be a template for what that looks like, and it will be very transparent and clear. And more importantly, there'll be publicly available audit criteria. So if someone sees that certification, they will know what that means. And it's really important that we maintain the independence, because they have to also believe that we have checked to make sure that indeed all of the criteria have been satisfied and all of the statements that have been made in the documentation are actually true. And so this is what comes out at the other end. And so this is, there's more that we can say here, and I'm going to pass this off to Ben. This is just a snapshot of some of the criteria and what it looks like. And, I think we advocate for this as a position in general, even if you don't work with us, right? I think we advocate for having transparency in this process, and it's going to avoid sort of a race to the bottom for a lot of these things. And so we're happy to open this up for questions, and we're happy to give you more materials so that you can further understand exactly what this sort of audit would entail. Ben?
Perfect. Thank you so much, Shay. So this concludes the presentation part of our webinar, and I've already kind of had a glimpse at the different questions. We've already got questions trickling in, so I'd move us along now to the Q&A. So for those who haven't asked the questions, pop them in the chat, and I'll call them out now as I see them here. So we have a first one, Shay, from a machine learning practitioner in insurance from London in the UK. and he's asking, or she, why is there only specific regulation on bias audits for ADT and only in NYC? And second, are there any other upcoming AI regulations on bias audits for other AI algorithms anywhere in the US? And I know we actually have an appendix. It's always good if you have an appendix and you can say like, well, we cover this here. So I'm just going to pull up this slide before I close this. I think maybe Shay, that can be a basis for kind of answering that question.
Yeah. I mean, so it's a good question in the sense that, why isn't this being done everywhere? And I think the problem is there's not a lot of political will to do a lot of this, and at the federal level, and so I think it lies on municipalities and states to be sort of defining or requiring some of these things. So if you're in London, there's still this kind of thing still applies to you. If you're recruiting out of New York City, and I think a lot of people are recruiting out of New York City, there's a real potential that you do fall under this, and so it is relevant there, and there are going to be regulations. So in different states, California is coming up with another one. California law is slightly different in the sense that you notice that there was nothing about validity in any of this. And so validity is typically a way of getting around or explaining disparate impact. That we have a valid test and there's different kinds of validation or validity that you can have, criterion-based content and concept validity. But California is going to be focusing on that. But it's important to point out that the EU AI Act, hiring is in the high risk category. And so conformity assessments, which, whether they're going to be something that third parties have to do or it's internal, it's probably going to be internal. But conformity assessments are going to be there for these tools under the EU AI Act. And so I feel like this is a good impetus for starting to think about these issues and how you document it and how you test these systems to be compliant anyway, because it's going to be coming very soon.
Perfect, thank you. So I think I'm going to move us on to the next question. Thank you, Shay. And I'm going to put us here in the focus, in the spotlight. So the second question that we have here asks, what exactly is Babel certifying? That the software has no bias, or that the way the employer is using the software does not introduce bias? That's a very good question.
Yeah, so this is really apropos to the ambiguities in the law and some of the complications with the vendor-employer interaction. So what we are certifying is very straightforward. We have outlined criteria. In fact, in the most simplest case, there's only 13 criteria for what we think is the minimal possible testing that for disparate impact that you should do. And so things like describing what the test data set looks like, what are the demographic variables that are being tested, how did you source that data set, how do you define an adverse outcome, and how does that turn into what you would call a selection rate. So it basically articulates the steps in the process that it takes to do a disparate impact. And what we are certifying is that the entity, whether it be an employer or a vendor, has gone through the process of fulfilling those criteria. Now, what does it come out at the end? There are certain things that we leave up to the employer and or the vendor to define for themselves. So you have to make a decision about what is important in some sense for disparate impact. And so if you're an employer, you could just look at the numbers. And in some sense, those numbers, like you're using the tool. There are people who are getting selected out, people who are getting selected out of a candidate pool. And in some sense, the way you use that tool, which is critically important for how disparate impact gets propagated, is captured in those numbers. Now, if you're a vendor, this is much more complicated because potentially you have to test in a way that is sort of abstract from disparate impact. But the criteria would apply to you nonetheless, and you would describe exactly how you are reasoning through that. And so one of the things we didn't mention is that we do require a very basic risk assessment, which essentially is something that we think is part of our mission. It's critically important to do, I think, at a practical level. That risk assessment is supposed to think about those issues. So in the case of a vendor, how could the way an employer use our tool affect disparate impact, and make a justification why the data that they're using is sort of representative of that. So the thing that we're actually certifying is that these people have fulfilled the criteria. Here are the criteria, you can see them, and we've verified that the claims that they made, there's sufficient evidence to believe that they have indeed done what they said. That's the certification.
Thank you, Shay. I have another question asking about the role, if any, for software producers. So the participant here asks, if a software producer has, say, 1,000 customers, will they have to support 1,000 customer audits with different auditors? How can we find efficiency here?
Yeah, that's a really good question. I think there's no way of getting around the fact that employers have to have responsibility for this. And so there's different levels of software producers. So there are people who are producing the AEDTs themselves. They have a lot of information about or a lot of control over what, they allow employers to do with their tool. And they can construct testing which covers a wide range of cases. And they also know whether they have to be very specific about the different employers that are using the tool, and whether it has to be a bespoke thing. In which case, they can simply give information to the employers and say, this is the testing that we've done, but then you need to verify that it, however you're using it or turning the knobs, does not produce disparate impact. Now, there's another level where there are some AEDTs are using third-party software, like from larger companies or individual vendors, and that becomes more difficult. I think that it's hard to put it's hard for those people to think about auditing their software in such that it was applicable to everybody. However, we've already seen that there have been cases where it's difficult to get any data about testing from some of these APIs or software as a service, and that's something that can't happen. And so if the vendors who are producing the AEDTs are relying heavily on third-party software, there has to be a conversation there about understanding what testing has been done and making sure that if you don't have any documentation from that, you need to do it yourself. So I don't know if that helped. I think there is going to be a scale problem here, but in the end, the employers are the ones who are currently on the hook.
Yes. So another question, Shay, that we have is fairly straightforward, just asking how often do the audits have to be done, and will re-audits be faster? Which I think simple yes to the second one.
Yes to the second one. So they have to be done every year, and so it has on a yearly basis. And they will be faster the second time, in the sense that a lot of the work will be onboarding, figuring out who is responsible, who in your organization is the one that's going to communicate with the auditors. And the auditors, a lot of times, are going to have to come back to verify claims. And so can I see the GitHub repository for, you said that you had this kind of data, can we see it? And there's a chance that that is going to, exactly who to talk to the second time around. And so I think that it will happen much faster, and there will be a lot more efficiency as you work with the same vendor, whether it's us or somebody else. But we're hoping us.
Thank you, Shay. We have another question from Benjamin Kultgen, I think German. He's asking, would a company be in compliance if the AI is found upon independent assessment to not be biased, but the overall process, hiring, promotion, is found to be biased?
Yeah. So let me first say that there's actually no requirements in this law that there not be disparate impact. And this is important because there are many tools that are going to show a disparate impact. And that is actually okay under the law if there's some validation or there's some business need or there's reasons for it. And so that's just my first point, is that they actually don't specify that that's something that has to happen. Your point, though, is well taken, that if your AEDT is found to not have disparate impact, but let's say the employer that's using it, if it turns out that their end-to-end selection procedure has disparate impact, well, the standard procedure, let's say if somebody's investigating this, the EEOC or New York City, they would look at the individual components, and when they get to your component, presumably the testing has been done and you don't show disparate impact. That's likely not going to be on you because you've already shown that it doesn't have disparate impact.
Thank you. The next question comes from Deborah Weisman. She's asking, do you anticipate the bias audit population to be limited to NYC applicants, or can employer conduct the audit on a larger general population? What will be done if the NYC population of applicants is too small to, for example, get a reliable evaluation of bias disparate impact? That's a very good question.
Yeah, I think absolutely. I would expect that it would be okay to have a larger pool. I think there's unless you want to argue that somehow inherently New Yorkers are different than let's say other Americans that might live on the East Coast, for instance. I think that it would be hard to justify not doing that, or hard to come up with a strong argument against doing that. And especially if you have small numbers, I think it would be required because small numbers can cause a lot of problems. And so if you need to go broader, this is from the employer side. If you need to go broader, I think it makes a lot of sense to include those numbers because I think they would still be fairly representative.
Great. Next question comes from Heather Doman, and she's asking, Shay, can you please speak more about your view on how companies should integrate the NYC law efforts into their wider AI governance efforts? Big picture question.
Yeah, no, I think that's really good. I think one thing this highlights, this is kind of the first example where specifically for these kinds of algorithms, you're going to need to show your homework, so to speak. And I think what's key here is an audit trail and documentation. So if you look at what's going to be required under probably the most stringent one, which is the EU AI Act, it's fairly heavy in terms of documentation. Now, some of that may get thrown out before it actually goes into effect. But even if half of it got thrown out, there's still a huge amount of documentation that's required, and things like post-market monitoring. So this is a good wake-up call to start thinking on a small scale, okay, we need to document this process. We need to have regular testing, and we need to be communicating with some sort of independent assessors in order to do this. And so I think it's a good opportunity to start thinking about how does this plug into larger AI governance. And so one of the things that we think, the reason that we're asking for a risk assessment is because we want people to start thinking in terms of risk and governance. And so it's a good opportunity. I mean, if people were to, let's say, use our certification scheme, it's a good opportunity to start bringing together a collection of people whose responsibility it is to oversee the risks associated with your AI. And so this is a good opportunity to, if you haven't started, to start connecting those pieces, the technical side, which is a lot of the testing, and then this sort of cross-functional team, which is supposed to be providing oversight. And if you already have some oversight, this is a good opportunity to start thinking about, can we bring in people other than just the compliance team? Or if you have a structure like model risk management, how do we start closing the loop on all of these? Because that's kind of what's required for this. You got to close the loop. You got to have responsible parties, and you got to produce documentation that's going to be shown in some sense to the world. I mean, first instance, it would be, in our case, to independent auditors, but the public summary gets shown to the world. And you could potentially have Department of Consumer and Worker Protection knocking on your door asking to see it. And so I think it's just it fits very nicely. It's like a baby step towards something that might be much more strenuous, which would be the EU AI Act.
Thanks. I think we have a nice follow-up question here that I've just seen. And this person is asking, to your point just now, Shay, how do vendors and employers ensure that we, say Babel, don't reveal too much in the audit or in the public summary?
Well, that's a good question. Well, So let me first say that there's some ambiguity as to what's in it, and what needs to be in it, and there's going to be some rulemaking from the department around that. But this is something that we agree on before we sign the contract, and so it's part of the independence that we have to be very, very clear as to what's included it and what's not early on. And so we can send you documentation about how the process actually works, but there's a scoping process where we essentially delineate what is it exactly that we are looking at and certifying, and we agree ahead of time on what that public summary is going to look like. And so that's and of course the companies themselves are doing the testing and submitting the documentation. So there is a lot of transparency on your part as to what is going to go into the public summary. You've done the testing, you know the results, and our job mostly is to make sure that you've fulfilled the criteria, and that's something that everybody can see what the criteria was.
Thank you. Next question we have, probes a bit, the relation between employers and vendors. So this person is asking, can employers rely on vendors' audit results, say?
Yeah, this is the $1 million question, I think. I think for sure people are going to do that. I think because it depends on the use case. So there are some cases where, let's imagine in a certain part of the recruitment funnel, like if you're using a platform. So if there's a platform where the platform is feeding you potential candidates for employment for a particular job, then you're not going to have, as an employer, a lot of access to information about the pool of candidates that were coming through. And so here that necessitates, I think, a strong involvement, or there's a strong argument that the vendor has to be the one that is doing a lot of the testing. And it may be that you are communicating with the vendor and they provide you that information, or the vendor just does some very generic testing, which they can argue carefully that it does apply to all of their employers. But there are some cases where the employer has the demographic data and that the vendor actually does not. And so in those cases, it makes a lot of sense that the employer record the demographic data of the candidates going through the AEDT, and that they simply would submit that documentation to us, because the testing itself, it's fairly straightforward how to do this kind of analysis. And so it makes a lot of sense in those cases where the vendor doesn't have a huge amount of testing and there's a lot of, let's say, control that the employer might have about how it's used. It makes more sense there that the employer is the one that's doing the testing. But I do think there are appropriate cases where a vendor can do the testing and the employers can point back. I think there just has to be a clear argument as to why that is appropriate. It has to be articulated very clearly and publicly why that's appropriate.
Thanks. So I'm conscious of time. I want us to go through one more question, so I'm just going to pick one here, Shay. So we have one asking, do you expect the NYC Corporation Council to come out with guidance ahead of January effective date? And I know we're already in talks with authorities here, but that's also a very good question.
Yeah. So, I mean, they've said to us at least that yes, that there is going to be more rulemaking around this. And I think that we can expect that that's going to come out before January. I think there has to be. Now, there is a little bit of a worry that if they're going to go conservative and try to do minimal guidance, because if they go too stringent, then during the public commenting process, there's a potential that there are so many comments and there's so much, let's say, anxiety about it, that it's difficult to change what they put in the rulemaking, or there'd have to be another round of comments. And so there's a real possibility that the guidance is minimal and that it will be left up to the market or the employers and the vendors and litigators to sort of sort out what a lot of these ambiguities mean. But there definitely will be some rules.
So unfortunately, we're at time. I know there's some questions which are unanswered. So I would just encourage you, if you have any other follow-up questions, do get in touch with Shay or myself. overall, thank you for joining us for this first webinar, which will be the first one in a bunch of ones that we're planning. And of course, we've mentioned this, if you're interested in some of the follow-up materials or kind of our overall approach, of course, feel free to approach us as well. So on that note, thank you everyone for joining, and we're looking forward to the next webinar. Thank you.
Yep. Thank you very much.